Lordship, yes, Lord. That's the
or 15.4.
Yes, Lord. The question that is being asked.
Yes.
Yes.
341, if say exceed, that does not provide for reservation. It only provides for what would be scheduled caste.
Lordship, yes.
And then the reservation is provided under 16.4 or 46, provide that it shall be the duty of the state to make special provisions for advancement of scheduled caste, scheduled tribe and backward classes.
Lord, I would
Or for the purpose of 330.
Lord, I would respectfully submit, my Lord.
Would it not hit at the very concept of Article 14?
Yes, Lord. I quite see that, Lord. I quite see that. May I make my respectful response to what comes from my Lord's Lord? I would submit, my Lord, that this is the precise scheme of the Constitution. The scheme is that we will identify. And when identified, this submission that comes from the other side is actually questioning the scheme itself.
No, they don't question the scheme. They don't say that the identification is not correct. They say that among that identification,
allow us.
There are certain classes which are more disadvantaged.
I quite see that.
And therefore allow us to bring equality in real sense.
What is being put to me is, Lord, that having identified, say 39 in Punjab, we have 39, exactly 39 in Punjab. Why can't the state, what is being put to me is, why can't the state say that on experience we find that Mazhabi and Balmikis, they deserve some extra preference, 50%.
Special treatment among the special.
Among the special. Why can't they say, especially your Lordship put it to me, in view of 16.4? Why? Because is it not an equality doctrine which is being followed by them? And if they are doing it, what is wrong? Where is the bar? That's as I understand the question. My respectful submission is this, Lord. That this exercise of equation has been done and there is a mechanism to change it. And there is
you yourself argued.
Yes, Lord.
There is no provision for variance. So either include or exclude.
Yes, Lord.
So if there is neither a necessity for inclusion,
yes,
nor a necessity for exclusion,
and
but still there is a situation,
yes,
that some classes among that class under 341,
yes,
have reached a particular level,
yes,
and others are still at the bottom.
Yes.
Would some tinkering in that,
yes,
would not be permissible without touching the
list
special,
itself,
without touching the list or the special provisions to everyone who are included in that list?
Lord, kindly see me, Lord. This exercise, Lord, therefore the word deemed comes, my Lord.
One more
Lord.
aspect you need to consider.
Lordship.
In 4,
yes, my Lord.
It says any backward class.
Yes, my Lord.
That's the widest term used. There are 3 lists, 341, 342, 342A.
Lordship.
Can the state not identify another class as a backward class which is not included in 341, 42 and 42A?
It is being said so, my Lord. It is being said so
No.
that
the state do it or not?
Lord, I'm sorry, my Lord.
Can the state do it or not?
Lord,
under 16.4.
It is being said and authoritatively said in Indrasani that 16.4, please don't read it as limiting the power.
Correct.
Because the opening words are, nothing in this article shall prevent the state from making any provision.
Significantly,
yes,
16.4 doesn't use, it uses the expression backward class.
Yes.
It doesn't use the socially and educationally backward classes.
Any backward class.
Any backward.
But at the same time,
yes, Lord.
But at the same time, it doesn't use the word caste or tribe.
Right.
Caste or tribe.
It has to be a class as a whole.
Yes, Lord.
So the state would have the powers to make reservation for the backward class, not for the caste or tribe. So that fine distinction.
Class because they are in 341, 42, 42A.
Backward class which is not adequately represented.
Yes.
That has to be seen, not a particular caste.
Yes. Otherwise, my Lord, I'm very grateful, my Lord. Otherwise, that will be classification on the basis of
There
caste.
is a difference between caste and class.
Yes.
And see, all this would fall under SC. The backward class would include SC, ST, and SEBC.
Lordship.
So that would be a class by itself.
Yes.
It's not caste.
So class benefit is contemplated. Lordship, yes. Lordship. Lordship, yes. Benefit can accrue to a class as a whole. And we not kindly see the facts in Thomas. Lordship, yes. Yes. Caste. Yes, yes.
Dhruv,
Lordships,
tell us one thing.
lordship.
Does Indira Sahni continue to, insofar as subcategorization is concerned?
OBC, backward and more backward.
Right.
Yes.
It permits that subcategorization for the
Indira Sahni did.
OBCs. We'll call them OBCs just as a.
Backward, more backward.
Now, Indira Sahni permits the subcategorization.
It does.
Is Indira Sahni overruled by the 2018 constitutional amendment?
My lord, it substantially, my lord, when I take your lordships to the debate, it's very interesting, my lord.
Indira Sahni continues to be good law. What does the 2018 amendment for Article 342A do?
It does this, my lord.
See,
Sorry.
Under 341 and 342, in relation to the scheduled castes and scheduled tribes, exclusive power is vested in Parliament. Right?
Lordship.
What 342A does is that each 342A breaks it into two. It gives the exclusive power to Parliament in relation to the central list for the purposes of the central government.
Yes, my lord, yes.
Right?
Yes.
342A1 refers to two things: the central list for the purpose of the central government.
Yes.
Right?
Yeah.
341 says for the purpose of the constitution. That's the other distinction. Now, 342A clause 3
State.
allows the states also.
To have an independent list,
for
separate
the
list.
For the purpose of the state.
States.
In fact, it says for the purpose of the state.
Yes.
Every state or union territory may by law prepare and maintain for its own purposes.
Purposes.
So, it has bifurcated 341 and 342 into two.
Yes.
By giving the states also the power to notify.
In regard to SEBs.
Now, notwithstanding this, the logic of Indira Sahni in regard to subcategorization into the backward and more backward is not taken away by the 2018 amendment which was made by Parliament. They could have done it, but they have not done it.
But kindly see.
Therefore, the logic of subcategorization in relation to the OBCs, which was brought about in Indira Sahni, still continues to hold the field, notwithstanding the 2018 amendment.
Lord, kindly see.
Now, if that is so,
Yes.
would it not be appropriate to then to read that the power of subcategorization is also implicit in 16.4 itself?
Lord, kindly see, my lord. 342A.
Subcategorization which 342A permits is not subcategorization, is actually, I used the wrong phrase.
Two lists.
It contemplates that there can be two lists.
Yes.
A central list for the purpose of the central government,
Yes.
a
State list.
state list for the purpose of the
State
government.
Yes.
So what is the distinction, as I said, between 341, 342 and 342A?
For the purpose of the
There's
constitution.
only one list,
Yes.
central list made by Parliament. Two, it is for the purpose of the entirety of the constitution.
Lordship, yes.
Right?
Yes.
Now, is there something intrinsically in 342A which would indicate that 342A recognizes the power of subcategorization, which 341 and 342 don't? There is, the hypothesis which I want to place before you is, there is nothing in 342A in regard to subcategorization, just as there is nothing in 341 and 342
Yes.
in regard to subcategorization.
There's nothing.
Despite that, Indira Sahni recognizes the power of subcategorization between the backward and the more backward. And 342A was not there when Indira Sahni was pronounced.
Lordship.
So even before Indira Sahni, even before 342A is brought on the constitution by the 2018 amendment, our court reads the power of subcategorization. Where does it locate it? It locates it not in 341 and 342, but it locates it in 16.4. Therefore, the insertion of 342A does not alter that position.
Lord, I would respectfully.
If that did not alter the position, though Parliament could have while making the constitutional amendment, then why do we recognize it in relation to scheduled castes also?
Lord, I would respect.
At a conceptual level, Brother Gavai just said, for instance, otherwise what will happen is that the more advanced among the scheduled castes, they will grab all the benefits. In fact, Brother Gawai, you can tell that example of the MBBS.
Yes.
In Maharashtra,
Yes.
till 1985, there was not a single candidate from Mehtar community who had got admission in MBBS. So for the first time in 1985, that too through court, he could get admission. Unfortunately, I was his lawyer.
Fortunately.
Fortunately.
Very fortunately.
Must be a super specialist.
So from that, so he didn't go to that. He became a doctor MBBS, he got a government job. He became a doctor, came and met me. It's packet of sweets. So that was one of the most happiest moments for me, that it was a pro bono case. For 35 years after the constitution came into.
If I may say so, fortunately, you're a judge now. That's also fortunate.
For 35 years, and it is one of the most disadvantaged. Either Bangi, you know, they have to do the job of scavengers. And
Not responding to, not making a.
now the position in at least in Maharashtra is that sometimes the merit list for MBBS of general category and the SC category is almost same. Because of Indra Sawhney, many of the scheduled caste persons get admitted in a general category because they can compete with the general category candidates. Because Indra Sawhney says that those who are admitted in category, they can't be counted in scheduled caste category or scheduled tribe category.
I mean, it's not sub-categorization, it is categorization for the purpose of definition.
Reservation.
SCPC.
Categorization for the purposes of giving a beneficial treatment, so as to remove inequality.
Correct. So it's not sub-categorization as such. Constitutionally, it's not per se sub-categorization.